20th, 2025. And this hearing is being conducted via video at the Board of Partisan Parole Central Office in Carl Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Joaquin Figueroa, 426-821.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, good morning. Hannah Dean on behalf of Mr. Figueroa.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better, weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Figueroa, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I'm leaving it with Hannah right now.
Perfect. So we're going to go over your rights quickly for today's hearing. So first, you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I have a paper that they had sent me.
Perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So in charge number 1, the condition of absconder, the charging officer reported that on 9/6/24 at approximately 12 p.m., you signed out of Bishop House, your only approved PCS residence, on an approved community pass to CCAR, located at 132 Grand Street, Waterbury, Connecticut. It is expected to return at 3:30 p.m. Once you failed to return to Bishop House, staff attempted to contact you on your cell phone and was unsuccessful. Local hospitals and jails were contacted, but you weren't admitted to either. Your whereabouts remained unknown in the community, and you failed to contact Bishop House staff or your assigned parole officer. And then on charge number 2, the condition of travel, the charging officer reported that on 9/3/25, you were apprehended in Amsterdam, New York by Amsterdam police and charged with fugitive of justice. On 9/4/25, you appeared in the Amsterdam, New York City court and signed a waiver of extradition. You did not have permission to leave the state of Connecticut, and based on your actions, you were in violation of your police condition travel. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the parole violation notice, Exhibit B, the parole conditions, Exhibit C, the halfway house agreement, Exhibit D, the Bishop House incident report, Exhibit E, the Bishop House discharge report, Exhibit F, the remand to custody order, Exhibit G, the parolee rights, Exhibit H, the waiver of extradition, and Exhibit I, the parole violation report. In addition, they did submit an addendum to the parole violation report on September 8th, 2025, and that reads that on October 15, 2024, the Board of Pardons and Paroles issued a warrant for re-imprisonment for Mr. Figueroa, and that on September 3rd, 25, Figueroa was apprehended by Amsterdam, New York Police Department based on a lead from P.O. Howlett. On 9/24/2025, Figueroa was extradited back to Connecticut, where he signed his parole violation notice and parolee rights, and a remand to custody order was lodged. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have. Thank you.
Thank you. And then I did receive an exhibit from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any additional documents at this time?
We do not. Thank you.
So we have no witnesses. So it is now the defense's opportunity to call any witnesses, present evidence, and to speak to the charges or any of the evidence submitted. So counsel?
Yes, thank you very much. Just kind of some background information, sort of surrounding this whole situation. So my client had been on parole in the community for about 3 years without issue. He was doing excellent. He had never received a misconduct. While he was placed at Bishop House, it was due to his sponsor being unavailable. She had moved out of state, got a different residence, so he did need somewhere to stay. At the time, my client had previously been residing in New Britain and indicated a preference for a halfway house in that general area or Hartford due to the proximity to his employment and the resources he'd already established for himself in Hartford and New Britain. We do acknowledge that sometimes parole is limited on available beds, but this ultimately led to him being placed in Waterbury at Bishop House, where he was not familiar and didn't really know the available resources in the area. Initially, this was all right. My client was still permitted to travel to and from work in New Britain. He was working at Eastside Restaurant, where he was making great career strides. He was getting good hours. He was enjoying his employment. He had found a friend and mentor and one of the chefs there who was previously working as a culinary director for DOC and who had tried to advocate for my client on his behalf to parole concerning his employment. He also reports during that time he was volunteering with CCAR and was trying to be an asset to the halfway house, taking it upon himself to do additional chores and help care for the common spaces there. Unfortunately, he does report there being some difficulties with the halfway house director. He indicates that there were some concerns regarding his job. The halfway house director did not want him working there due to the proximity to Waterbury. My client did try and advocate for himself and spoke to the supervisor at the halfway house, and that staff member eventually was removed from the position. Once a new director came, my client again reported all this information. He was permitted at that point, I believe, to still work at the New Britain job. This was fine for a little while, and then his PO kind of changed her tune and wanted him to also lose that job. It, I think, did create a lot of discouragement in my client. He, I know, had inquired about transfer to New York to reside with his family, where he also had more services, given his excellent track record and the fact that he was doing so well. But I think he was feeling discouraged, like some of these requests weren't being considered. So that was just kind of the background I wanted to note. I also want to note concerning travel that my client was cooperative. Once apprehended with the process to return to Connecticut, he voluntarily waived extradition and came back to respond and handle this violation. And then at the appropriate time, I would like to talk about my client's background. Thank you very much.
Thank you. I'll just take a moment, then I'll announce my findings. On charge number 1, Mr. Figueroa, the condition of absconding, I am making a finding based on state's exhibits B, D, E, and I. And for charge number 2, the condition of travel, I'm also making a finding based on state's exhibits B, H, I. And that is all. So that does conclude the fact-finding portion of this hearing. Before I do make my recommendation, you'll have an opportunity to speak to your background history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So, counsel?
Yes, thank you very much. My client's 52 years old, born and raised in Brooklyn, New York, prior to moving to New Britain in 2017. His primary support is his significant other, Ms. Chavez, who resides in New York. My client has 4 kids, 32, 23, 17, and 16, who reside in Brooklyn with their mom. He does have a good relationship with them. And he also has a stepchild and a grandchild from his partner. Upon release from Robinson to special parole in 2021, my client successfully completed Eddie's Center. He was sponsored by his sister, sponsored by an aunt. He utilized the REACH program in New Britain, successfully completed Cheney House, and then was at Bishop House for a little while. Within the first 3 to 4 months on supervision, my client reports that he had obtained many certificates from Best Chance for a Second Chance, including his scaffolding, first aid, fire safety, and OSHA flagging, several different things. As noted, he was employed full-time at Eastside Restaurant in New Britain for about 1.5 years, cooking, dishwashing, doing maintenance. He reports voluntarily attending CCAR and then also volunteering his time with them at the Waterbury location. My client, while at Bishop House, reports attending reentry groups through the agency's reentry center. Since being remanded to custody, my client had applied for a tierman position, and he is on the wait list for the New Thoughts program. I would note that my client, I think, is kind of, a model inmate. He's never received a single DR despite his time incarcerated. Upon reinstatement of his parole, he would like to be transferred, if possible, to New York to reside with his significant other. However, in the event that he is placed in Connecticut, he's open to a halfway house in any available jurisdiction, but his preferences would be for, Middletown. I know he has a prior good experience with the Eddy Center or Hartford halfway house, just due to the proximity to his prior employment and the services that he's familiar with in the area. In New York, my client could return to working with a friend doing painting, construction work. In Connecticut, he's open to all career opportunities. He is a hard worker and I know is very eager to get back to work. He's open to all treatment recommended as well, including reestablishing his prior care. I am asking that you consider a sanction for my client not to exceed 3 months. He has I think a pretty good track record on parole. I understand it's an absconding violation. However, he was doing well in the community for about 3 years. There weren't issues. He was compliant with the process. He's been doing great in DOC. I believe this is his first special parole violation. And again, he was out for about 3 years before this violation occurred. Mr. Figueroa, is there anything I didn't cover that you want to state at this point? You don't have to, just if there's anything I didn't cover.
No, just I guess, it's the way that she has spoken is it's everything that I needed to speak about too as well, if she didn't represent me. But she's doing a great job. She's done everything that I need from her, and all I ask for is an immediately release because of my reactions of being the criteria of a candidate being good.
Thank you very much.
Thank you. I'll announce my recommendation in a moment. So I have listened to the testimony today. I've also reviewed all the evidence submitted. With that, Mr. Figueroa, I'm going to recommend your parole be revoked and that you serve an approximate year. I'm going to do a 5-month period of confinement is going to be my recommendation, and that's with a re-parole date of February 3rd, 2025, because I am going to take into consideration the time you were in New York when they picked you up. And I'm also going to recommend the following conditions: behavioral management program for anger management, no contact with victim RR, and halfway house placement. So what happens next is that my recommendation is going to go to the board on February 4th, 2025. The board can do 3 things on that date. They can lower that recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a length of confinement longer than what I've recommended, you'll be called back for another hearing to answer their questions, concerns before that's imposed.
And I just wanted to clarify, I think you may have said 2025 for the sanction. It obviously is February 2026, and then the board review is December 4th. It's all good. I just wanted to make sure it was clear for the record. Thank you so much.
I couldn't even get through the first one. Yeah, sorry, February 3rd, 2026, Mr. Figueroa. And I do just want to comment on the New York travel. You do have to show a period of compliance in the community before you put that request in. You would just have to ask your ask your supervising officer if they can submit a request, but I heard about 3 months of compliance. I don't know if that's true or not, but just a period of compliance before you ask the request to be put in to go to New York. Okay.
Right.
So yeah, it's February 3rd, 2026. Any questions at this point?
Excuse me, sorry. Is that another hearing on the February 3rd?
No, you, I believe, are on special parole. So you would actually, if they approve it, you would get out that day, February 3rd. We'll know for sure once the Board of Pardons and Paroles votes on her recommendation. That's going to happen December 4th. So if you'd like, I could set up a call with you for, the following day and just kind of update you on what they decide. Okay.
Also, whatever they decide December 4th, then
yes.
I'll be released February.
If they give the thumbs up and they rubber stamp what she recommended, then you would be getting out February, that day.
Okay.
All right. I'll set up a call with you so that we can discuss everything.
All right, thank you, and I appreciate it. Thank you very much for the time. I appreciate it. I don't know your name, I'm sorry. But I appreciate the recommendation.
Yeah, no problem. Good luck to you. Just, try to do it the right way, okay? You get out there, it's not a no all the time. Just try to stick with it, all right? And get to New York if that's where you want to be. The right way.
Well, it's like I said, as the time as I'm being in here or the time I'm out there, there's not going to be ever any type of arrests anyway or violations. I violated, I have to pay the consequence.
Thank you, Mr. Figueroa. Well, good luck to you, okay?
Thank you.
Thank you very much. I'll talk soon.
Revocation hearing of Joaquin Figueroa, inmate number 426821. Thank you, Attorney Dean. Have a good day.
Thanks. Have a great day, everyone.
You're all set, Mr. Figueroa. You can leave or go back to the dorm. Let us go now. Thank you.
Thank you very much.
Good morning. How are you?
Hi, good morning. How are you?
Great. If we can start with Mr. Matthysse, that'd be perfect.
Okay, I think he's on his way through the gate right now. Just a minute.
Okay, no problem. Thank you. Good
You're
morning,
welcome.
Attorney Jones.
Good morning. Good morning.
It's in the middle. Keep going. Keep going. Next one. Have a seat.
Good morning, Mr. Matthysse. How are you?
Good morning. I'm good. Yourself?
Good. So I just want to let you know it is 10:27. We cannot start until exactly 10:30, so we'll begin in about 3 minutes, okay?
Yes, ma'am.
Morning.
Good morning.
I feel like this is a long 3 minutes.
Feel like the longest 3 minutes of my life. I'm so
I
anxious.
believe it. I'm sorry. It's gonna turn soon, I promise.
Yeah,
But it is a long one.
yeah. It's like I'm so like my anxiety is running like through the roof right now. I'm sweating.
So we are gonna get started. Are you ready?
Yes, ma'am.
All right. So good morning. I'm Parole Officer Chisello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brian Matthysse at number 372016. Today is Thursday, November 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Brian Matthysse, 372016.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you violated one or more of the conditions to your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Matthysse, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over your rights for today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges. Did you receive that written notice?
Yes, ma'am.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am. I'm ready.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So in charge number 1, the condition of GPS, the charging officer reported that you had GPS home violations on the following dates and times: 6/21/25, 9:58 p.m. to 10:35 p.m. 6/23/25 from 9:25 p.m. to 10:22 p.m. 7/4/25 from 11:30 p.m. to 11:58 p.m. 7/13/25 from 9:04 p.m. to 9:33 p.m. 7/20/25 from 10:30 p.m. to 10:49 p.m. and 7/24/25 from 9:04 p.m. to 11:55 p.m. You had a GPS battery shutdowns on the following dates and times: 7/8/25 from 3:54 a.m. to 4:10 a.m. 7/12/25 from 5:29 p.m. to 5:29 p.m. 7/22/25 from 4:27 a.m. to 4:24/25 at 2:05 a.m. 7/24/25 from 2:07 a.m. to 2:09 a.m. 7/28/25 from 9:49 a.m. to 9:29/25 at 5:16 a.m. 8/1/25 from 4:24 a.m. till 5:30 a.m. 1:30 p.m. and till 8/2/25 at 6:01 a.m. 8/3/25 from 4:27 a.m. to 4:44 a.m. and 8/5/22 from 8:18 a.m. to 8/8/25 at 3:19 a.m. and 8/9/25 from 7:29 p.m. till 8/12/25 at 1:12 a.m. On charge number 2, the condition of program participation, the charging officer reported that you were unsuccessfully discharged from the Explorer domestic violence program for having 5 absences. Lastly, for charge number 3, the condition of obedience to the law, the charging officer reported that on 9/3/25, approximately at 5:15 a.m., Hartford police officers responded to 13 Webster Street in Hartford, Connecticut due to a 911 hang-up, later learned to be a domestic incident. The person who called did not answer any callbacks from 911. Officers did not hear anyone in the area scream or act in distress when they reported to the location. Hartford PD dispatch received another phone call stating that you were in the caller's vehicle and would not get out. When officers approached the vehicle, they observed you in the front passenger seat. You then exited the vehicle and started to run away. The officers began a pursuit and told you to stop running. You stopped running and said, "I give up." As officers attempted to place handcuffs on your wrist, you pulled away and started to run away. Per the report, you said, "I can't go to jail." The officers eventually caught up to you and placed you in handcuffs. Per the report, you resisted the officers when they were handcuffing you. When officers went back to talk to the caller, she stated she just wanted you out of her vehicle. She stated you did not harm her physically. Per the report, you stated that you and the caller were having a verbal argument only, and that the caller was upset with him because another girl contacted your cell phone to buy weed. Subsequently, you were arrested for disorderly conduct and interfering with an officer. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the Connecticut Conditions of Parole; Exhibit B, the Connecticut Board of Parole Remand to Actual Custody Order; Exhibit C, the Notice of Parole Violation / Notice of Parole Rights; Exhibit D, the Parole Violation Report; Exhibit E, the Hartford Police Incident Report; Exhibit F, the GPS monitoring agreement for Parole Community Services. Exhibit G, the Judicial Branch Court Support Services Division Explorer Discharge Report. Exhibit H, the Offender Misconducts. Exhibit I, the State of Connecticut Board of Pardons and Parole's Decision Information Summary. Exhibit J, the State of Connecticut Board of Pardons and Parole's Decision Information Summary Update. And Exhibit K, the State of Connecticut Judicial Branch Pending Case Detail. The state also did submit an addendum to the parole violation report on October 8th, 2024, and that states that under docket number 879S was disposed of on October 7th, 2025. The disorderly conduct charge was nullied, and the interfering with an officer resisting, you received an unconditional discharge. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Thank you. And I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any additional documents?
No.
So we do not have any witnesses today. So it is now the defense's opportunity to call any witnesses, present evidence, and to speak to the charges or any of the evidence submitted. So counsel?
Yes, thank you. In regards to charge 2 under program participation, my client does explain that he was sponsored to another residence that was no longer within close proximity to the program. He was unable to transfer the program, and therefore it resulted in him having the absences. Up until that point, he had gone and successfully completed, I believe, 4 of the classes. And then in regards to charge 3, the addendum is stated accurately, just noting that my client did receive an unconditional discharge, and the disorderly conduct, which would be classified in this situation as a domestic, was nullied.
Thank you. So I'll just take a moment, and then I'm going to announce some findings. So on charge number 1, the condition of GPS, I'm making a no finding as the state failed to submit sufficient evidence to meet the preponderance standard for the charge. On charge number 2, I am making a finding for the condition of program participation based on state's exhibits A, D, and G. And on charge number 3, I'm finding, Mr. Matthysse, that you did violate the condition of obedience to the law based on your conviction of interfering with an officer and resisting. When you received a sentence of unconditional discharge on October 7, 2025. In addition, the evidence that supports the charge is states exhibits A, D, E, and K. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the hearing is to help determine what outcome I will recommend. So counsel, would you like to state?
Yes, thank you. My client is 32 years of age. He's single. He does have 1 child on the way. He receives his primary support in the community by way of his grandmother, his mother, and cousins, all of whom reside in the Hartford area. He is a high school graduate of East Hartford High School, as well as has attended some college at Capital Community College, where he was enrolled in a general studies program. He was in the community for approximately 4.5 months prior to this violation. I believe this is his first violation of special parole. During the time period that he was in the community, he successfully completed the Connecticut Renaissance Halfway House program located in Waterbury. He also was with the CRT Scattered Site Housing Program in Hartford, where he remained until his remand. He also indicates that he attended the domestic violence programming up until he was discharged from that program, as well as individual psychotherapy. He held employment in the community working at Bazzuto's. He was there for approximately 3 months before suffering a work-related injury to his finger. He's now, during the time period that he's been within the Department of Corrections, he's been attending AA, volunteering as a tierman. When he's reinstated to parole, he is asking to be placed in a halfway house in the Hartford area. He does have his employment to return to at Bazzuto's, located in Cheshire, Connecticut. He also would like to pursue, by way of education, his CDL at the New England Tractor Trailer Training School. Taking all things into consideration, the fact that this is his first violation, the nature of the violation, he received an unconditional discharge in court. We would be asking that he, excuse me, one moment. Okay, that he receive a sanction that would not exceed a 4-month period of time. Thank you.
Thank you. Just take a moment and then I'm going to announce my recommendation. So I did listen to the testimony today. I've reviewed all the evidence submitted. I am acknowledging that this is your first violation, Mr. Matthysse. However, you do have a history of domestic violence, and this is another DV charge, and that's concerning to me because this is also a new victim as well. So now I have 3 victims. So I am just concerned with the behavior, and then you also didn't do the DV program. With that, though, I am going to recommend. Just really concerned. I'm going to recommend your parole be revoked and that you serve an approximate 7-month period of confinement as a sanction. That's with the reparole date of April 3rd, 2026. I'm going to recommend the following conditions: a behavioral management program for domestic violence, no contact with victim JB, a general no contact with TL, a general no contact with TG, and mental health evaluation and treatment as deemed necessary, and halfway house placement in Hartford. So what happens next, Mr. Matthysse, is that my recommendation is going to go to the board on December 4th. On that day, the board can do 3 things. They can adopt my recommendation, they can lower it if they choose to do so, and if any reason they would want to see a longer length of confinement, they'll be asked to come back for another hearing to address their questions and concerns before that's imposed. So that does conclude today's hearing. Do you have any questions?
Yes, so when does that date, you said April 3rd?
April 3rd.
All right.
So the board, Mr. Matthysse, the board has the final say. So if you want to contact me after December 4th, when the board has met to review your case, I can let you know exactly what they said.
Okay.
Okay?
Yes, ma'am.
Okay.
How do I get in contact with you? Can you say, I don't have your number or anything?
Just go through your counselor. Let them know you want to contact the parole revocation unit. They know how to contact us.
Okay.
Okay?
Yes, ma'am.
Okay.
So this includes the revocation hearing for Brian Matthysse, inmate number 372016. Good luck to you, Mr. Matthysse.
Thank you.
Thank
Thank
you.
you, Attorney Jones. Have a good day.
You too.
Hello.
And Mr. Dwire, I'm just gonna go find your attorney, okay? I think he's
How are you?
outside.
Okay,
Good,
thank
how are
you.
you? Great.
I'm good, thank you.
It is Mr. Dwire. To get started. So good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Andrew Dwire, inmate number 392580. Today is Thursday, November 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Andrew Dwire, 392580.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself?
Sure. Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Mr. Dwire.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better weightier evidence must establish that, or probably that not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Dwire, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. And the state is not present at today's proceedings. However, you'll have an opportunity to present any relevant documents. And sorry, I just lost my spot.
Okay.
Yeah. And testimony. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak towards your background and history. Do you have any questions about the purpose or procedure before we begin?
I do not.
So
I
you do have
understand.
important. Yeah, perfect. So you do have important rights for today. So your first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did receive, yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. To understand these rights, now you're ready to go forward.
I do.
We're going to review the charges now that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of absconder, the charging officer reported that on 2/5/25, you left the Sierra Center halfway house without authorization. You had no further contact with Sierra Center staff or this officer. You left your only parole-approved address without program completion or permission and became unaccountable in the community. Subsequently, your whereabouts in the community were unknown. Charge number 2, the condition of obedience of the law. The charging officer reported that on 2/15/25, you were arrested by New Haven PD for violation of Connecticut General Statute 21A-267A, use of drug paraphernalia 53A-167A, interfering with an officer resisting, and 21A-279A1, possession of a controlled substance. You were released on a promise to appear with a court date of 3/19/25 at New Haven GA 23. On 3/19/25, you failed to appear for your scheduled court date and a rearrest order was issued. On 7/15/25, you were arrested by Plainville PD for violation of Connecticut General Statutes 53A-139, forgery second, 53A-130, criminal impersonation, 53A-96, unlawful restraint second, 53A-167A, interfering or resisting, 53A-181, breach of peace second, and 21A-267A, use of drug paraphernalia. On charge number 3, the condition of drugs, charging officer reported that related to New Haven PD case incident report. On 2/15/25, you were in possession of numerous wax bolts containing fentanyl. And on charge number 4, the condition of halfway house placement, the charging officer reported that on 2/5/25, you left your only parole-approved residence, the Sierra Center halfway house, without authorization and didn't return. You failed to contact your parole officer, halfway house staff, and you failed to return to the program. Your whereabouts are unknown at this time. Also, your actions violate your signed halfway house agreement, specifically the clause which reads, "I will not leave the physical confinements of the halfway house unless authorized by a program staff or parole. I will only go to the locations indicated on the approved community pass unless changes have been authorized by staff." The state has submitted the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed parole conditions, Exhibit F, the signed halfway house agreement, Exhibit G, the Sierra Center halfway house incident report, Exhibit H, the New Haven PD case incident report, now case number 25-6661, Exhibit I, the Connecticut Judicial Web pending case detail, docket ending in 486S. Exhibit J, the Plainville PD case incident report number 25-9880. And Exhibit K, the CT Judicial Web pending case detail, docket ending in 758S. The state did file an addendum, 2 addendums to the parole violation report. The first was on 7/18/25. And states on 3/5/25, the Board of Pardons of Appeals issued a warrant for imprisonment On 2/15/25, Dwire was arrested by New Haven PD for use of drug paraphernalia, interfering with the officer, resisting possession of a controlled substance, and was given a promise to appear for GA 23 New Haven. On 3/19/25, Dwire failed to appear for his court date, and a rearrest was ordered. On 7/15/25, Dwire was arrested by Plainfield PD and charged with forgery second, criminal impersonation, unlawful restraint second, interfering, resisting, breach of peace second, and use of drug paraphernalia. A remand to custody order was lodged with Plainville PD. On 7/16/25, Dwire appeared in New Britain PD under the docket ending 758S for his arrest on 7/15/25, and probable cause was established. He then appeared in New Haven Court on 7/17/25 for the arrest from 2/15/25, and probable cause again was established. And an additional charge of failure to appear second was also brought up. And then the second addendum was submitted on 10/20/25, and that states that on 10/6/25, Mr. Dwire appeared in GA 15 for the charges of forgery and criminal impersonation, unlawful restraint, interfering, resisting, breach of peace second, and use of drug paraphernalia. All the above charges were nullified with the exception of interfering with an officer, where he pled guilty and was found guilty and sentenced to 6 months jail. And then on 8/7/2025, you appeared before GA 23 for the charges of possession of controlled substance and failure to appear. You pled guilty to both charges, and you were sentenced to 6 months jail for each charge under that docket ending in 486S. The charges of use of drug paraphernalia and interfering with an officer resisting were not pursued. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
Thank you. I did receive an exhibit from the defense, Exhibit 1, on list of parole accomplishments, future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
Sorry?
Do you need time to submit any other documents? Yeah. Okay. So we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Yes,
Counsel?
just briefly. Andrew, you've been on parole since May 8th of 2024, and you were remanded on July 15th. If my math is correct, approximately 14 months, correct?
That is correct, yes, sir.
Okay, this is your first violation.
This is my first violation, yes, sir.
Okay, and while you were out, just a yes or no question, were you working?
Absolutely, yes.
Okay, under charge number 1, Andrew, for the absconder charge, the allegation is you left the Sierra Center without authorization on February 5th of 2025. Did you, and now you're under oath there, did you actually go to work on February 5th of 2025?
Yes, sir, I did.
Okay, and on February 5th, is that the same day that you relapsed?
So that specific night, yes, that is the same day that I did relapse, yes.
Okay, and did you learn of a diagnosis of that your mother had on that particular day also?
Correct. My mom was diagnosed with colon cancer and is actually in the later stages of it and doing pretty bad, actually, yes.
Okay, and so you relapsed on February 5th of 2025, and then charge number 2 under obedience to the law. Is it a fair statement? You're still using it approximately 10 days later, you're arrested.
Yes, sir.
Okay, and then you were supposed to go to court about a month later, and you failed to appear, and the rearrest was ordered. That's correct?
Correct, sir. Yes, sir.
Okay, and on July 5th, there was an arrest in Plainville, and you were still using at the time, correct?
Correct, yes, sir.
Okay. Were there any illegal substances at the halfway house you were staying at?
So up until that point, yeah, the halfway house that I was placed into was excessively saturated with drugs, and which is what really led to my relapse. Prior to that, I did exceptionally well on my own, and then I was later remanded back to the halfway house, which was the cause of my demise. I mean, I did do exceptionally well on my own. Yes, sir. Yes, I did. And yes, the drugs did come from the halfway house. Excuse me. Yes.
Okay, so you're out approximately 14 months, and your testimony is, and we're going to cover a little bit more where you were prior
Sure.
to the halfway house. You did well, and you were working during that time frame.
Yes, sir.
Okay. I don't have anything to add. I know typically this comes into the second part of the hearing. I just wanted to give you a timeline of what happened here, and they all lines up. He uses on February 5th. He gets arrested 10 days later. doesn't appear in court, gets arrested again about a month later. But his demise, as he indicated through his testimony, was a substance abuse. That's his first violation. Not like he's, been back 3 or 4 times. So anticipate, you have the addendums, you got to make the finding in those charges. I don't have a problem with. I just wanted to give you a little background.
Sure.
Thank you.
Thank
Just take a
you.
moment, I'll announce my findings. On charge number 1, Mr. Dwire, I am finding that you violated the condition of absconder based on state's exhibit B, E, and G. On charge number 2, I'm also finding you violated the conditions of obedience to law based on your conviction of the possession of controlled substance and failure to appear on 8/7/2027. And with your conviction of the interfering resistant on 10/6/2025, you received 6 months jail for each charge. In addition, the evidence that supports the charge is states exhibits B, E, H, and I, J, and K. I'm also going to use the testimony from today as supporting the charge. On charge number 3, I'm finding that you violated the condition of drugs based on the testimony today, as well as states exhibits B, E, and H. And lastly, on charge number 4, I'm finding that you violated the condition of halfway house placement states on the evidence presented in states exhibits B, E, F, and G. So it does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation is to help determine what outcome I recommend. So, counsel?
Yes, on behalf of Mr. Dwire, my client is 40 years old. He does have one child. He has a son who's age 16. On his release to transfer parole, looks like back in December of 2023, he did successfully complete the Project Moore Halfway House program to Walter Brooks in New Haven. Then from May 2024 to September 2024, he's sponsored by his fiancee, Ms. Weeks, in West Hartford. And it looks like September 2024 to October 2024, he did successfully complete the Adams Foundation, the residential services inpatient substance abuse program.
Yeah.
And then he was at the Connection Halfway House, the Sierra in New Haven. He did graduate from Notre Dame Prep High School in Fairfield. As far as the employment was mentioned, full-time for the Lombardo building in Trumbull. Been there for approximately 9 years. And through this position, he indicated he did complete various safety and OSHA programs. Regarding his behavioral health treatment, he did indicate to us that it was like April of 2024, he did complete an intake with Mr. Diaz at Midwestern Connecticut Council, MCCA in New Haven. It was for alcohol. He was not clinically recommended to any treatment for that particular issue. And then it looks, as I indicated, September to October 2024, he did complete the Adams Foundation. And he also reported to us he did complete intensive IOP and participated in aftercare with MCPA. Even while he'd been incarcerated since July, he is employed in the kitchen 7 days a week from 4 in the morning to 12 noon. He's enrolled in carpentry classes and he's on the waiting list for voices. He does have his sponsor again, his fiance, Ms. Weeks, who lives in Plainville, and her phone number is listed. He is interested in taking a real estate course. And he's indicated he established a lot of strong connections, opportunities in this field of real estate through his job with Lombardo Building. Companies indicated to us that job is still available to him. Andrew, anything you want to add regarding your background or regarding anything I left out? The second part of the hearing, not the actual charts.
Just as far as, I did put in a substantial amount of time of being very much a productive member of society. And I know, given the second chance again, I would absolutely do the same. Again, really just my demise was being put back in a situation that was saturated with drugs. And unfortunately, I was too weak and I fell victim to that. But knowing what I know now, I could almost guarantee those would never be options again. I mean, I'm completely sorry about putting myself through this and putting my family through this. The extent of what actually took place in my life is very detrimental, considering even the short amount of time that I was here. It was very detrimental. And I just don't want to go through that much longer. Please.
Thank you for your comments.
Thank you.
Just take a moment and then I'll announce my recommendation. I have listened to all of the testimony today. I've also reviewed all the evidence submitted. That I do just want to note things. So I do see that this is your first violation, but you're also on discretionary parole, which means you were serving a sentence while in the community as well. And you did get arrested twice while you were out in the community on founder status. So I am going to recommend, Mr. Dwire, that your parole be revoked and that you serve an approximate 9-month period of time as a sanction. And that's with no new parole date. In the event the board wants to lessen my recommendation, the following conditions are going to be recommended. So behavioral management program for domestic violence, no contact with co-defendant Jeffrey Sackis, no contact with victim KB, and halfway house placement. So that is my recommendation. What happens next, Mr. Dwire, is that it's going to go to the board on December 4th. On that date, the board can do two things. They can adopt my recommendation, or if for any reason they would want to see a shorter period, they can give any date between December 4th and your end of sentence in April. So you'll be notified within a week or so after that hearing date of what their final decision is.
So
So as
Andrew,
of right, go ahead.
as of right now, she gave you your EO date, which is April 5th, but it's going to the board, as I indicated to you, on December 4th. They have the authority, if they choose to give you less time. You and I will get something in writing about a week to 10 days after December 4th with the final outcome, okay?
So as far as so I believe that I had a date in January also, January 5th date. Is that a possibility for me?
So that January 5th date is the earliest, actually, now that you say that.
Yeah.
Thank you for correcting me. That's the earliest that they can give you. So on December 4th, when they vote, they can't give any date from, like I said, I'm sorry, I apologize. Thank you for bringing it up. They can't give any date before that January 5th date. So that's the earliest that they'll give. And then they can go any date in between that date and that end of sentence in April, okay?
Just gotta hang tight for that board review first, okay?
All right, I appreciate it.
All right, good luck to you,
Thank you
Andrew.
for talking to me today. So good. I'm luck to you, Mr. Dwire. This concludes the revocation for Andrew Dwire, and number 392580. Thank you. You're welcome.
One and then back up?
Yeah,
All right, I'll wait on it.
Good morning, Officer Shep. How are you?
Good morning. How are you?
Good. I'm gonna connect to, where am I going? Oh, Corrigan in about like 2 minutes, just because it's a little early. Actually, I'll probably start now. We have 5 minutes because maybe they will just answer.
Okay,
All right,
cool.
Thanks. Good morning. How are you?
Good, you? We'll get them right down.
Okay, and if possible, can we start with Mr. Aceto?
Aceto?
Yeah.
All
Thank
right.
you.
Well, we're gonna be out in a minute.
Thanks.
They want to start out. We're a little late. Yeah. Enjoy. Yeah. Definitely, that we consider the problem.
He just shut it off. All right.
Good morning, Mr. Aceto. We're gonna get started, okay?
All right.
Great. So good morning, I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Chad Aceto and number 759. Today is Thursday, November 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Chad Aceto, 396-759.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your charging officer. Can you please identify yourself for the record?
Parole Officer Shep, Hartford Parole.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state and IU has a responsibility to prove the allegations by preponderance of evidence, and that is a better way to your evidence must establish that, or probably then not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you, placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oaths. Mr. Aceto and Officer Shep, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights. The first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So, Mr. Aceto, were you informed you could have an attorney represent you for today's hearing?
Yes.
Do you intend to hire anybody for today?
No.
No. So just to confirm, you're willing to move forward without legal representation?
Yes.
Thank you. So you also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
And were you able to review it?
Yes.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights now? You're ready to go forward.
Yes.
Thank you. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. But I do want to note on the record that charge number 1, the condition of GPS, it will not be taken into consideration at today's hearing because a no finding was made at the preliminary hearing and no new evidence has been submitted for that charge. So Officer Shep, can you please review charge number 2, obedience to the law?
Charge number 2, obedience to the law. On 10/30/2024, you are identified as a suspect involved in a kidnapping and serious assault. The victim sustained 3 skull fractures, a broken nose, a fracture to the left eye orbit, several broken/cracked teeth, several lacerations to the face and skull, and a broken leg. The assault took place in the rear parking lot of 195 Affleck Street, Hartford, Connecticut, and was on camera footage from the residence where it took place. The assault involved multiple individuals and the victim was beaten with a baseball bat. On 10/30/24, you were observed on camera in front of 745 Park Street, Hartford, Connecticut, lingering in front of a white scooter. Moments later, a white Acura TL that is involved in the assault pulls up to you. At this point, you have a brief conversation with the suspect who exits the vehicle and is dressed in all black and carrying a baseball bat. The suspect then walks to the alley where the assault took place. You were seen on video watching the assault and observed the white Acura TL flee the scene with the victim in the trunk. You were then seen on video returning to the scooter. One of the assailants involved in the assault gets on the back of the scooter and you drove them away from the scene. Subsequently, a warrant was issued and signed by a judge for conspiracy to commit kidnapping first and conspiracy to commit assault first. You were arraigned at GA 14 on 11/12/24, and probable cause was found. You had a $300,000 bond and a next court date of 11/26/2024.
Thank you.
The evidence, sorry, go ahead.
Sorry. Well, so we did already review the evidence because you did have a preliminary hearing that went forward. So we're not going to review those. Those all remain the same. I
Okay.
do see you did submit additional evidence. I'm going to just identify that as Exhibit K. I'll call it information from DOC. Correct? Because you just submitted that one new document.
I did.
So we'll identify that today as Exhibit K, information from DOC. So you did also submit an addendum to the parole violation report on October 29th, 2025. Can you please just review that one as it's related to the charge?
Yes, on October, just real quick, I did not print that one.
If not, I can do it.
Yeah, I'm sorry, I didn't print that one out.
Oh, that's fine. So on October, the addendum was submitted on October 29th, 2025. It states that on October 21st, 2025, Mr. Aceto was seen in GA 14. The charge of conspiracy to kidnapping in the first degree and conspiracy to assault first degree were both nullied. Mr. Aceto does not have any pending charges at this time. So Mr. Aceto, did you receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Correct.
Thank you. And you, again, one more time, were able to review that, correct?
Correct.
Thank you. I have not received any exhibits from you at this time. Would you like to move forward, or do you need time to submit any documents?
No, we can move forward.
All right. We don't have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted and the charges presented. So Officer Shep, would you like to make any statements towards the charges at this point?
I do. Mr. Aceto was involved in a very serious and very violent assault that left the victim deceased. His charges were nollied on 10/21/25, and nollie is not a dismissal. It is the court merely stating that they are not choosing to prosecute at this time. Despite the nollie of the criminal charges, the behavior that was displayed where Mr. Aceto watched a serious assault take place that later led to the death of the victim, and Mr. Aceto drove one of the assailants away from the location of the crime is still present. Based on the evidence from this assault, Hartford Police Department later determined that this was a Solitos-based hit on the victim. Based on the fact that Mr. Aceto played a part in this assault and later determined to be associated with the Solitos, he was placed on the SRG unit and designated a Solito on 4/16/2025. Mr. Aceto is presently in stage 5 of the SRG program and will complete the program on.
Officer Shep, we do have to focus just on the charge against him. So that is all aggravating information.
Okay.
So anything additional for the charge?
Nope, that is it. That's the end of it.
So I'm just going to take a moment and then we'll announce my findings. I'm actually just going to take a quick recess based on the information. I will go back on the record shortly. Just give me a moment. I just want to remind everybody we are still live streamed, even though the record will be on a pause, okay? All right, so I just wanted to like make the notes of what was just testified to. Mr. Aceto, you do have the opportunity now to respond to the charges or any other comments presented by the state. But just remember, you do have the right to remain silent if you choose to do so. So do you have any statements at this time?
I do.
Okay, go ahead.
Well, yes, this is a very serious case. No one's disagreeing on that, but this case had nothing to do with me. And there was a blatantly multiple things that was said in this police report that on video contradict what was said. For one, it said that a suspect vehicle pulled up next to me and had a brief conversation. That car pulled up 30 feet away from me and never once had no conversation. Nothing was said to me. And it says that I was lingering in front of a white scooter, where this is where I was working at. Parole knew I was working at the barbershop. She had the address to the owner and the address. I'm not lingering where I'm supposed to be. For months prior to this incident, my GPS will show that I was there. Two, it said the assault took place in the back of 195 Affleck, and I'm quote unquote lingering in front of a scooter. So how is it physically possible for me to know that the victim was placed in the trunk? I can't see through buildings. And lastly, it says that I drove someone away from the scene. I never disputed again on my scooter. I went up the street to go get some food. I never left Park Street. Went a few blocks up that I already called my food in before this incident took place. And I came back with the same person on my scooter, same clothing, same everything, within 3 to 5 minutes later. You don't drive someone away from the scene if you're coming back with them. And lastly, it's when I got my parole papers, well, through the police report, but since we're talking about this case right here on the parole papers, it says that on evidence is that when the detectives stumbled upon video, they found the victim the day before when it happened on the 30th, and they said the 31st when they was coming, they just happened to stumble upon video. And there was just throughout this whole case, there was multiple detectives lying blatantly. It's the reason I got 5 years and 3 years special parole 2019 was off the same Hartford City cameras. There was no victim, no witness, no weapon recovered. They told me video is just as good, if not better than anyone, because video does not lie. The same cameras that convicted me 2019 and why I'm on special parole right now is the same cameras that showed straight contradiction and cleared me. I didn't plead guilty. I didn't nothing. From the very beginning, I was waiting for all the discoveries to come out, everything. My very first offer was this case getting dismissed. I didn't plead guilty. I wasn't given no offers, nothing. Well, I'm not disagreeing that this is very serious charges, but I came home. I wasn't in the same neighborhood where I caught my case. I didn't even parole to the same area. I went all the way across town. I got a job in a whole nother area where I'm not from, nothing. And the same detectives is the ones that also wrote a letter to DOC and said I'm a confirmed gang member, but with no evidence. The hearing officer in Wethersfield, when they came to me, said, we have to have 3 to 5 identifiers to affiliate you. He said, I can't tell you one reason why you're a gang member. All I have is a letter from this detective saying you're a confirmed member, and that's all it says. He said, I've never gone on such little piece of paper. I have no pictures. I have no groups of people. I have even no gangs. I have nothing to say you're a gang member. And while I understand, and the victim, he never died behind this case. He died months later to an overdose. And through the autopsy, the medical examiner said that. He did nothing to this case. He died from this case. And my whole thing is 2019, when I got this 5 years and 3 years special parole, the cameras was good enough to convict me off video. But the same cameras that convicted me is what freed me.
Yeah.
And I'm not asking for no special. I'm just asking to go put back on my parole test because I didn't violate my parole. This case never had nothing to do with me. I was where I was supposed to be. I was working at a barbershop. I wasn't where I caught my case at. And nothing in this case goes with my criminal history, anything. I've never had no assault, no kidnapping. I've never been arrested for anything with a baseball bat. There's nothing on this case that goes anywhere line to line with my case, my history.
Thank you, Mr.
I didn't.
Go ahead.
I didn't cut my brakes. I didn't run. I didn't do nothing. Parole called me, told me to come in on a day I wasn't supposed to. I came right in. These are very serious charges. So the charges overweigh what I owed on special. By the time I was home 6 months, I had 2.5 years of special parole left. The kidnapping one starts at 10 years. So it overlaps my special. It's like I did it a week before my birthday. How I just missed 5 years of my life. I've been sitting for a year for something that had nothing to do with me. And it's this, everything keeps coming from this detective that blatantly lying. You're saying the right things like, oh, a car pulls up next to you. It's this, but video doesn't show that.
Thank you, Mr. Aceto. I do appreciate your comments and statement. I'm going to take a quick recess again, unless any additional comments from either side before I do take a quick break.
No, I have one question. Mr. Aceto, did you ever provide documentation about working? You say that you were working at a barber shop. Did you ever provide me with any sort of documentation that you were working at that barber shop?
I gave you my boss's number and the address, but when you work at a cosmetology, you pay to use the chair.
So it was under the books job, correct? It was off the books?
Yes, but you knew that.
Okay. Also, is that a Salitos run barber shop?
Not to my knowledge.
Okay, that's it. That's all I have.
Thank you. Anything new from your side, Mr. Aceto, before I do take a quick second?
No, that's it.
Thank you. Again, I'm going to go off the record just to review some information, and then you guys are still live.
Can I say one more thing?
As long as it's new, yes, absolutely.
No, it is new. This incident had nothing.
Hold on, and related to the charge, because we're only in the.
Yes, to this charge. This kid, everything keeps saying about nothing happened where this never had nothing to do with where I was working or anything.
Thank you.
I never met never knew any of the people. I don't even know the victim. Never seen the victim a day in my life before any of this. So it's like, none of this had to do with where I was at. The person was walking down the street and the car stopped right wherever they came from. And the victim, where he was walking, wherever he came from. It had nothing to do with where we was at. The victim wasn't at the barbershop with me. I've never had contact with the suspects or the victim. So that's it.
Thank you. Yeah, it's just going to be a quick recess. I just want to go over some information, and then I'll announce my Sunday.
Pietrosello, you're muted.
Thank you. At least I didn't say 2026. Sorry about that. So I am back on the record. And I have reviewed, well, I listened to all the testimony at today's hearing as well as the preliminary hearing. I've also reviewed all the evidence submitted. Based on that, Mr. Aceto, on charge number 2, the condition of obedience to the law, I'm making a no finding of the preponderance standard for the charge, the condition of obedience to the law due to the lack of sufficient evidence to meet that standard for the crimes that you were charged with. Mainly based on the testimony and, like I said, the lack of evidence to meet that preponderance standard for those charges that were brought against you. So with that, I am going to reinstate your parole effective today. The records office at the facility is going to be notified of that reinstatement, as well as your officer is now aware of it. Just quickly, Mr. Aceto, any housing availability? Do you need a halfway house?
Yes.
What location?
Hartford.
Hartford. So I'm going to process that paperwork now to get it over to everybody who needs it. And like I said, your parole will be reinstated effective today, okay?
So when will I be leaving?
Today, especially. You'll be released today.
Today?
Today.
All right, thank you.
All right, so this concludes the revocation hearing for Chad Aceto and me number 396759. Good luck to you, Mr. Aceto.
Thank you.
Thank you, Officer Schapp.
Hey, what are you doing? I'm going home. You can't just run out of there. I'm sorry. You can't just run out. I'm sorry. So go back in for a second.
Mr. Aceto, don't ruin this.
Yeah. All set? Yeah. I won't run out.
Hi, Mr. Rogers, how are you?
Good morning, how are you today? I'm doing well, thank you.
Good. I just need a few moments to process the paperwork quickly for the previous case, and then I'll grab your attorney and we'll get started, okay?
Yes, no problem.
Thank you. Come on in. All right, we're gonna get started, Mr. Rogers. So good morning, it's still morning. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Henry Rogers, inmate number 335688. Today is Thursday, November 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
Henry Allen Rogers, number 335688.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. This morning is your attorney. Can you please identify yourself for the record?
Sure, Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Mr. Rogers.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is better weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend a revocation, I'll make the recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You need to know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Rogers, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for today. First, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Two important rights for today's hearing. The first is you have the right to be represented by an attorney. Counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I have, yes. Yeah.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I understand. We can move forward.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 1/15/25, you were at Windsor Motel with your girlfriend, Caitlin Daniels, victim, and victim's 3-year-old daughter. On 1/15/25, you were in the motel room, you were drinking alcohol. You and the victim engaged in a verbal altercation, which escalated to a physical altercation. This is violation of your release conditions. 1/15/25, you grabbed victim by her throat, which caused her pain and restricted victim's breathing. This is in violation of your release condition. 1/15/25, during this physical altercation, you grabbed a glass bottle of vodka, cocked the bottle back like a bat, and threatened to hit victim with it. 1/15/25, you pushed victim on the bed and restrained victim with your knee against her throat, which restricted victim from breathing. On 1/15/25, during physical altercation, you caused victim to sustain several bloody facial lacerations. A blood splatter was present in the motel room, and you admitted to GPD that victim's blood was on your clothes. Subsequently, GPD arrested and detained you for the criminal charges of risk of injury to a minor, 53-21, disorderly conduct, 53A-182, unlawful restraint, 53A-95, threatening to, 53A-62A1, assault third, 53A-61, and strangulation 2, 54BB. Based off your behaviors, your continued community release is no longer compatible with the welfare of society. On charge number 2, the condition of no consumption of alcoholic beverages, the charging officer reported that on 1/15/25, while in the motel room, you were drinking alcohol. You and your victim engaged in verbal altercation, which escalated to a physical altercation. This is in violation of your release conditions. The state has filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the Connecticut Conditions of Parole, Exhibit B, the Connecticut Board of Parole Remand to Actual Custody Order, Exhibit C, the Notice of Parole Violation, Exhibit D, The parole violation report, Exhibit B, the parolee rights, Exhibit F, the Groton Police Department report 2500001920. In addition, they did file an addendum to the parole violation report on October 22nd, 2025, that states that on 7/25/25, the offender was sentenced under docket ending 274S to the following: risk of injury to a minor, 1 year jail, strangulation second, 5 years, execution suspended after 1 year, followed by 3 years of probation and cost $20. And on the same docket, the offender was sentenced on 10/10/25 as follows: disorderly conduct, assault third, unlawful restraint first, threatening second were all nollied. Additionally, it is recommended if the offender is to be paroled, he is to have no contact with the victim, CD, and her minor daughter. No other pending cases. Please proceed with the revocation hearing. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified.
We did.
Thank you. I did receive exhibits from the defense. I have Exhibit 1, a list of parole accomplishments, a future plans for parole reinstatement. Exhibit 2, the Oregon Correctional Institution Addiction Treatment Unit Program participation. Exhibit 3, the Religious Service Department participation form. Exhibit 4, the Offender Accountability Plan, domestic violence, 2 pages. Exhibit 5, the Serve Safe Certificate of Achievement. Exhibit 6, the Unified School District Number 1 Certificate of Achievement, Culinary Arts and Technology. Counsel, do you need time to spend any other documents?
No.
We do not have any witnesses, so at this time it is the defense's opportunity to call any witnesses, present evidence, and to speak to the charges. So, counsel?
Yes, if I may, first part of the hearing is going to be the brief, because we have the disposition from court and you put that denim on the record, so I not in case anticipate. I know you're going to make a finding on charge number 1. I want to be heard for the second part of the hearing regarding Mr. Rogers' background, which I think is more important here than for this particular hearing.
Thank you. Going to announce my findings, Mr. Rogers. So with charge number 1, I am going to find that you violated the condition of obedience to the law based on those convictions. That's risk of injury to a minor and strangulation second on 10/10/2025 when you received a total effective sentence of 5 years jail, 1 year to serve, followed by 3 years of probation. In addition, the evidence that supports the charge is Exhibit A, D, and F. Also making a finding on charge number 2, the condition of no consumption of alcoholic beverages based on the evidence presented in State's Exhibit A, D, and F. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. So the purpose of this part of the hearing is to help determine what outcome I will recommend. So, counsel?
Yes, on behalf of Mr. Rogers, my client is 52 years old. I'm showing, hopefully this is correct, that he's been out since July of 2023. It was not remanded until January 15th of 2025. I know it's his first violation. I don't see any misconducts or any type of intervention in the paperwork that I received. So it appears he was doing well up until this incident. As I indicate, he's 52. He does have 4 children. Upon his previous release in 2023, he was sponsored by his sister in London, and he was there until he was remanded in January of 2025. Mr. Rogers did obtain his GED in 2006. And it looks like around 2019 to 2022, he did begin studying human services through Nantucket Community College. He's about halfway towards his bachelor's, towards his associate's degree. I apologize. As far as employment, he's been employed since he's been out in the community. He was employed as a mason tender and also worked full-time at the Covenant Shelter of New London. He actually worked both of those jobs simultaneously while he was out. He did report to us he did successfully complete IOP through Hartford Healthcare Nantucket Hospital approximately September 2024. Did report to us he attended NA meetings approximately 3 to 4 times per week, and he did establish his primary health and community health center in London. As far as since he's been incarcerated, all those exhibits that we submitted, we felt they were important to submit because a lot of times our clients tell us they're doing A, B, and C, and then we research and they're not doing A, B, C, D, or E. But in Mr. Rogers' situation, he's actually provided documentation of all the things he's done since he's been incarcerated. I know you put those on the record. I don't need to read these all again, but he's employed. He's doing AA meetings, he's doing religious services. He signed up for domestic violence classes, he obtained his safe certification, OSHA 10. So he's doing things even though he's incarcerated, and he was doing things when he was out in the community. As far as reinstatement, he is amenable to being placed. He's looking for the Fellowship House Ministries in Groton. And I believe his second choice was the Norwich area, and I'll ask him on a record afterwards. He does want to enroll at Three Rivers Community College to finish that associate's degree in human services. He's reached out to his previous employer. He can return to the Mason position, and he's amenable to all available job opportunities in the community and any treatment he needs to do. Mr. Rogers, anything that I left out about your background or what you're doing inside DOC and what the plan is for when you get out? We can't speak about the first part of the hearing, which is the charges, because that we have a disposition from court. But anything you want to add about your background or what your plan is when hopefully you're reinstated, what you're going to do when you get out?
No, I think you've covered everything. You're correct. I'm going to go right into the NA meetings, do whatever parole probation recommends, full-time employment, stay with my family, and just seek treatment. That's what I'm going to do and be a productive member of society. You're correct, sir.
Okay, and Mr. Rogers, I want to ask you one question. What I put on the record, from July of 2023 to January 2025, you had no issues with your parole officer, correct?
No, ma'am. No, sir.
Okay.
Nope, I've never missed a meeting, nothing. Yes,
Okay.
Yes, sir.
Thank you.
Thank you, Mr. Rogers.
You're welcome.
Then I'll announce my recommendation. So I have listened to the testimony today. I did review all of the evidence submitted as well, and you seem to be doing really well in there. So, I mean, I can't believe you got a certificate. Parole remand, I mean, pending cases. I'm impressed, honestly, because what counsel said, a lot of guys come in saying they're doing stuff, but I've never seen somebody actually complete something. So I'm sure there have been, but you've done a lot. With that, I do have to recognize just one thing is that this is a new criminal charge, and that you did receive that sentence. So with that, Mr. Rogers, I am going to recommend your parole be revoked and that you serve an approximate 1-year period of confinement. It kind of goes hand in hand with that new charge, but that's with the reparole date of January 16th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management for domestic violence, no contact with co-defendant Kayla Hill, no contact with victim LP, MP, and SJ, and in general, no contact with CD. They said a minor child as well. I guess I'll add that and let the board decide. So I'm going to do general no contact with CD and minor child as well. And halfway house placement. So what happens next, Mr. Rogers, is that my recommendation is going to go to the board on December 4th. On that date, the board can do a few things. They can adopt my recommendation if they choose to do so. If for any reason they would want to lower it, they can. And then a stipulation will be added, but we'll deal with that when that happens. So they can lower it anytime from that December 4th date through January 16th if they choose to do so. If for any reason they would want to see a period of confinement longer than what I'm recommended, they'll be asked to come back for another hearing to address their questions and concerns before anything longer is imposed, okay?
Yes.
So that does conclude today's hearing. Do you have any questions?
Yes.
Of course.
Go ahead.
I got
Hold on, Henry.
Do you have a question?
Before he asks this question, can you please take a look at, I am showing the max release date is 1/5/26 in DOC. Do you have a different date? Is that, Mr. Rogers, is it January 5th or I'm looking at DOC right now?
So at the moment, as we're speaking, I was sentenced, it was the 15th, on the October dates. I got 2 days good behavior. As we're speaking now, it's actually the 13th of today. But because as long as I'm doing what I'm supposed to do, I'll get 4 days for November and I'll get 4 days for December, which will bring it down to 1/5/26.
Okay,
Yes,
that's
sir.
where, if I may, I wasn't texting while we're doing it here. I have the Department of Corrections, and that's the max date I have. I have 1/5/26. And when I spoke to my client, it's like on November 10th, I did advise them, that's what the public DOC currently has?
So I have that, that's the projected EOS.
Okay.
Things happen. With that, I'm gonna keep it a year though, Mr. Rogers, because that's a year from when he was remanded. He was remanded on January 16th, 2025. So I'm gonna keep that date. The board can change it. So they'll be aware of that EOS date, but things change. He was returned from special parole charges January 16th, 2025. So I'm gonna keep the January 16th date.
On the 15th or 16th? Every day counts. I'm showing I was remanded.
I was arrested on the 15th.
Correct. You should,
It's a remand, so.
give me 1 second. I'm showing a remand custody at 15/25,
Okay, but now council.
the court date of the following day. This is what I have from the evidence. It says 1/15.
Okay, sorry then.
I know, every day counts.
Well, no, and everything, all the dates are different. So yeah, so absolutely, I'll go with the 115 then. So I'm gonna change it to the 1/15/2026, which is 1 year from the date you were remanded.
Okay.
So again, the board can do what they want. If they see that your end of sentence is less, they can choose whatever date they want to choose at any time. But I'm gonna stick with that 1 year from the date of remand of January 15th, okay?
Okay.
Any further questions?
Yeah,
sure. December 4th is the board date.
December 4th is the board date.
All right, so Henry, it's gonna go to the board for review on December 4th, about a week later or so. You and I will get something in writing with the final outcome of when your actual projected release date is.
Okay, yeah. Yeah, I just got one question about my placement. Will parole actually, if they recommend me to leave, a year, the 15th or whenever, will they be coming to get me to bring me to the halfway house? Is that how that works? Because I don't have a sponsor, so that's why I'm being placed in a halfway house. Plus, I think it'd be better for me not to live with anybody at this day and age. And what I plan on doing with my life is not to live with people, to get on my
It's on
own.
you. Absolutely. No, it's up to Parole and Community Services to coordinate your release. So yes, if you have no other means, they do pickups. I know that they kind of do drop-offs too, from what I understand. They'll work out a way to get you where you have to be that day.
They're gonna come see you prior to, is our understanding. Prior, close to your release time, someone's gonna be in touch with you or actually come and see you and go over everything with you.
Okay, so it is possible though that they'll go with the possibility to release me on the 5th, possibility? Considering it's good time.
Correct. When the board looks at it, they can look at the, as she indicated, the projected date, which was,
It was the
1/5, and she gave you a year from
Right,
your.
I understand that.
They
Yeah,
will take a look at that, and the board makes a final call.
okay,
So you'll know
Alright.
after that date, it won't be waiting. So after December 4th, you'll get something in the mail from us, probably within a week, letting you know their final decision, okay?
okay.
All right, good luck, Henry. Keep doing what you were doing when you get out. Was you on supervision for a few more years, but it looks like you were doing everything you're supposed to be doing
Yeah.
up until this
Thank you.
incident.
Thank
You're
you.
doing great.
All right, good luck to you.
Good luck to you,
Yeah.
Mr. Rogers.
Appreciate it from both of you.
Thank you. This concludes the revocation hearing for Henry Rogers, number 335688. All right, thanks, Mr. Rogers. You're all
Yeah.
set. Take care. Good
Yeah.
luck.
Yeah, thank you.
Hello.
Oh, good afternoon.
Good afternoon. You're Mr. Coleman, right?
Yes, ma'am.
All right, great. We're gonna get started, okay, Mr. Coleman?
Yes, ma'am.
So good afternoon. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Darnella Coleman, inmate number 4352225. Today is Thursday, November 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Yeah, Darnell Coleman, 435225.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. So this is a preliminary hearing, Mr. Coleman, and it has three purposes under Connecticut law. However, you are from a different state, correct?
Yes, ma'am.
All right, so we are not going to cover seriousness. So there's two purposes for today's hearing. So the first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. And the second is to determine if the act should, if you should be held in prison pending further proceedings for that act. So the state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause, you'll be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Coleman, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to, you can put your hand down. Thank you. Then we're going to review the parole violation charges that the parole officer is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present on today's proceedings. However, you'll have the opportunity to address the issue of probable cause. At the conclusion of the hearing, I will inform you of my findings, and that will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So do you have important rights at today's hearing? I'm going to review them now. So do you have the right to be represented by an attorney? And you may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney that we can help get to represent you. So, Mr. Coleman, did you were you informed you could have an attorney at today's hearing?
Yeah, yes, I have one. He couldn't make it today because he's in another court day. I think a trial or something.
Okay, so do you want to continue today's hearing for him to be present?
I didn't talk to him yet, so yeah, I can continue. I would like to continue.
Okay, I need his first and last name. Who is he?
I don't know about her, but he with the Black Law Group. That's all I know. Law Group, so, yes, ma'am.
Black. Do you know where they're out of?
No.
What town? What city?
He's like an hour away. That's all I know.
Black Law Group. And you don't know his first name?
No, I haven't got that yet. I haven't met him yet or nothing.
Any phone number information like that?
No, I haven't got that neither. It was just,
okay.
Yeah.
I don't know. They provided the document.
But he left. He said he left messages on my parole Kirby voicemail.
For Kirby?
To call him back.
If I told you a first name, would you know it? If I do a quick Google for him, would you know his first name or? I
know it's a father and son business. I don't know if it's a father or the junior.
You said father and son business, so yeah. Black Law Group?
Yes.
In Connecticut though, correct? It has to be, right?
Yes,
Connecticut.
ma'am. Yes, ma'am.
Black Law Group. There is a Black Law Group. Let's see. Two gentlemen on the page, Kevin Black Sr. and Kevin Black Jr. You think that's that?
Yeah, I just don't know which one who represents me, but I know it's the father and son.
So the son and Junior's, Kevin Black Jr.'s, you're the one representing you?
That I know of. I don't really know.
So you just know the group is?
Yeah, it's one of them. Yes, it's one of them. Yes, ma'am.
All right, I'm just gonna quickly jot down their contact information so we can maybe reach out to them to get them to, they have to file, so what they have to do, I don't know when you'll speak with them next, they have to file an appearance with us. So they have to contact our office here at the Board of Pardons and Paroles because they need to file an appearance. And that way they can be here to represent you at the next hearing. So I will accept your request for continuance for the attorney to be present. My next hearing date is December 1st. That's like a week and like 2 days away. Do you think that you need a little bit more time than that, or is that a good date?
No, that should be fine.
December 1st? Okay.
Yes,
So I'm
yes,
going to
ma'am.
need you to do some work on it too, though. I'm going to need you to ask for that legal call and get in touch with them and
Yes,
tell them
ma'am.
that they have to reach out to the Board of Pardons and Parole in Waterbury, okay?
Yes, ma'am.
All right, so December 1st, we're going to continue your case to for legal representation. And I'm just going to make note that this is them. It looks like they're in Danbury and Norwalk. Okay. Just so I have ideas to find them again. All right, so then we are all concluded for today, Mr. Coleman, and I'll see you in about a week or so, okay?
Yes, ma'am.
All right, talk to you then, and try to get in touch with them, okay? Have them reach
Yes,
out
ma'am.
to us.
Yes,
Not
ma'am.
Ms. Kirby, the Board of Pardons and Paroles, okay?
You said the border per what? Said again?
Board of Pardons and Paroles, not Officer Kirby. She's your charging officer, but we're the ones
Yes.
that need the documents. We're conducting the hearing. So yeah, in Waterbury, we're located in Waterbury. So just
In
have them
Waterbury.
try to reach out to us, and we'll try to reach out to them. Okay.
Yes, ma'am.
All right. See you in a few weeks. Good. Have a good day, Mr. Coleman.
You too.
Thanks. This concludes the preliminary hearing for Darnell Coleman, inmate number 43555. Oh, so 225. Sorry, 435-225. All right. See you soon.
Yes, ma'am.